Hello, my name is Lisa Sumner, and I am a member of the Creditors' Rights team here at Nexsen Pruet. In this video, I will talk about how to respond when you receive a demand to pay back a preferential transfer in a bankruptcy case. A primary goal of the Federal Bankruptcy Code is to promote fair distribution of the debtor's assets among creditors. One way the code does this is by giving the debtor or bankruptcy trustee the power to take or claw back payments that the debtor made to so-called preferred creditors before the bankruptcy petition date, and redistribute those funds to the larger pool of creditors according to the Bankruptcy Code's payment priority structure. Generally speaking, a creditor who receives a greater payment than other creditors in the same priority class must disgorge the payment so all similarly situated creditors can share the funds equally or on a pro rata basis. The law gives debtors and trustees about 2 years to file lawsuits to recover preferential bankruptcy payments, making it important for creditors to ensure that they retain relevant books and payment records after receiving notice of a new bankruptcy case. Typically, a debtor or trustee will send a demand letter to a creditor to repay an alleged preferential transfer before a lawsuit is filed. So many preference claims are settled before litigation even starts. Your response to a preference demand letter or lawsuit should depend on careful analysis of whether the payment meets the definition of a preference under the Bankruptcy Code, and if so, whether any of the code's defenses to preference liability apply. In a nutshell, think of a preferential transfer as any transfer of a thing of value, including money or a lien, made by the debtor within the 90-day period before the bankruptcy petition was filed, if that transfer was to an unsecured creditor and the transfer was made after the debtor incurred the debt or obligation to pay. In other words, payments on fully secured debts don't fall within the definition of a preference, nor do prepayments or payments made many months before the bankruptcy petition was filed. The Bankruptcy Code provides creditors with several defenses to preference liability, each of which can substantially reduce or even eliminate liability. Some of the most common defenses, such as the ordinary course of business defense, the contemporaneous exchange defense, and the new value defense, sound simple, but are applied by courts in a way that requires detailed technical analysis of the payment history between the parties. Spreadsheets with embedded formulas are commonly exchanged in preference negotiations. To complicate matters, bankruptcy courts in different jurisdictions do not always apply preference defenses the same way. When substantial amounts of money are at stake, these circumstances usually make it necessary for creditors to consult with an experienced bankruptcy attorney to determine what defenses are available and craft the most effective response to a preference demand. In most cases, debtors and trustees will agree to give a creditor more time to respond to a preference demand letter when they hear that the creditor has retained counsel to assist with analyzing your defenses. If you have any questions or need more information, please call me or any of the other members of the Creditors' Rights team here at Nexsen Pruet.